and welcome to Hospice Insights, the Law and Beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care.
Hospice audit updates. Hospices fare well in federal court. Now, Brian, here is a title that's just straight and to the point. No fun wording or anything, but this is all business here. We're in federal court in all of these states, all over the country. And I know we've talked about these on the podcast, but we actually have some really good and helpful news, not just for the hospices that secured those victories, but for the industry at large. So tell me what's cooking.
Right, Meg. And yeah, this is timely because it's just been in the past few weeks that our efforts that started, well, for you and me, Meg, it started decades ago when we were kind of figuring out these arguments and trying to find the opportunity to make them. And then 18 months ago, when I think we filed our first federal action, and then fast forward to March 31st of 2025, we got a couple of decisions. One of them out of Texas was a really positive decisions for that hospice, for the hospice community, because the court in that decision accepted all of our arguments. And what that means is, these cases are about challenging the ALJ, administrative law judge decisions. And we have seen, in our view, for some time that ALJs, their opinions kind of go over into them assuming the role of a physician when they don't have the medical training to do so. We believe they're rejecting our actual physician testimony without a good basis to do so, that they're applying the LCDs as if they were requirements and not guidelines. And they're failing to apply this statute that really gives hospices some latitude in making eligibility determinations, understanding how inexact that can be. And so this Texas case found in our client, that hospice's favor on all of those issues. We had lost at the ALJ. We got a fully favorable at federal court. So it's just a matter of remanding. And the court said, I'm going to send this back to the ALJ to order that this hospice reimburse the entire amount of that overpayment with interest. So it's really going to work out well for that hospice. So that was really a culmination of a lot of time and effort on our team's part in putting this all together.
Yeah, it feels, it's a great victory, but as you said, Brian, it's like stuff I've been jawing to you about for 17 years or however long we've been dealing with these audits. And the one that I think jumps out at me when you think about legal construction is just that statutory waiver of liability that was built into the law that said, and Congress was very clear, it's like hospices are insurance companies, act like insurance companies. They have to cover everything related to the terminal illness. So essentially everything at a very costly time in people's healthcare life. And, people shouldn't just willy-nilly take that money back if they disagree about 6-month prognosis because they've gone out and paid all these bills and paid these staff members. And so it's actually written into the law, the statutory waiver of liability. And we've been making, arguments to ALJs for decades about, hey, look at what Congress said, look at what the statute says. What meaning does this have? It never is applied. And so tell me a little bit more about what the judge decided in Texas on that front.
Right. And it's the ALJs have been consistent in the way they've approached that issue. Now, that waiver of liability or limitation of liability, it was based on a question of whether the hospice had a reasonable belief that it was going to get paid for the services it provided. In other words, it may have been right or wrong about whether the patient actually was going to die in 6 months, but it did at least have a reasonable belief that the patient had a terminal prognosis. The ALJs have handled this in a way that I think includes an inescapable contradiction. What they have said is CMS has published the LCDs, they have regulations defining terminal illness. All of that is out there for hospices. They can review all that. And had they reviewed all that, they would have known that these patients were ineligible. The contradiction is that CMS and Congress have said, with respect to the LCDs and with respect to those regulations, that prognostication is an inexact science. And even very good hospice physicians aren't always going to get it right. And this judge, no ALJ has really confronted that contradiction. This judge did. And he specifically questioned about the adequacy of the regulations and the LCDs to put that particular hospice on notice that these patients and their medical records that our experts said fully support eligibility, that somehow they should have predicted that they were going to get denied. The ALJ just said just those regulations are not enough. There's other ways that CMS could have shown a lack of reasonableness, but in that case, they didn't. And so we were able to win on that issue, and that's separate from all the other ones. If we only won on that one legal question, it would have been the same outcome. We would have won a full repayment with interest. So in all these cases, we have multiple arguments backing one another up, stated in the alternative, and it really paid off in that case.
Well, I guess the thing that cranks me, Brian, for decades, and you've listened to my tirades about this, is it's like, if you don't like this, change the law, but don't rewrite law by application and enforcement, because it does lead to this conundrum about, well, how do you reconcile the fact we have all this audit activity and recoupments and this big machine of audits, and then anytime you explain to a client this waiver of liability, limitation liability, it's like, how how do we have all of these audits? And obviously, when Congress wrote this, and it wasn't part of the 1983. I think was it in the late 90s, Brian, they added the waiver of liability, or early 2000s or something?
Yeah, I think it was in the late 90s. In that time frame, a version of this statute existed for home health, and then they added a hospice component because of the uncertainty of prognostication.
And so, as we all know, I mean, the LCDs don't answer the question. The regulation does not answer the question. Right?
Yeah.
Like, is someone going to die within 6 months? I mean, right? If we could predict that with like absolute certainty, but that's not what the law requires. It's like, was it reasonable? And so it feels like one of those victories that are like, it feels like common sense. It's like, well, this is what should have happened 15 years ago. But, with why we're now here is because there's just the audit activity has increased so much. And there have been, as we've talked about on the podcast, a number of ALJs who have issued very unfavorable decisions to hospice. So there's enough money at stake that we're going to these higher levels of appeal. And so, as you said, that started 18 months ago. And so this was a really exciting case. And I just think super reasonable in terms of just on that mere piece. Obviously, we won on other issues. And that decision is public. So, Brian, could we link that in our podcast notes to the court case?
Absolutely. It'll be in our notes. We'll provide a copy up there. It is there's a couple of decisions actually to get the full picture. Both of them very favorable to us, just the way the procedure worked out. So we'll link both of those, and you can see those. And when you do the kinds of volume of audit work that we do, we are very successful all the way through the appeal process, but with the increase in certain audits, especially these Center for Program Integrity audits, we've had some big dollar values get past the ALJ, which precipitated these court actions, which I think we're finding a silver lining because these court cases have the possibility of affecting downstream or upstream, whatever stream it is. But maybe this will affect how ALJs approach these and benefit everybody who is going before ALJs, that they just can't make the same internally inconsistent holding as they have been.
Yeah. Well, it was a great victory. It felt like, all right, already, this should have been the way things were. But as you said, Brian, it took a while because I think someone going to a forum that isn't, it's such boilerplate when you get a waiver of liability decision from an ALJ. It's like verbatim. And it's like, super short, a few sentences as to why it doesn't apply. So any other helpful takeaways from these cases, Brian?
Well, we have a number of these cases going forward. This Texas case is going to help our other cases. And it doesn't necessarily, success can be measured in a number of different ways. Certainly, this decision was a great success. We've had other clients in federal court, and CMS has approached us interested in trying to settle cases. There is risk in all of these cases. So winning is not a guarantee. So there's been some cases where we've been able to work with CMS on behalf of our clients to settle them and recover substantial parts of these alleged overpayments back from the government without really having to go through that process. So I count that as a win as well. If we're meeting the client's objectives of mitigating the amount of an overpayment, maybe not winning all of it, but winning back, high six figures from those. If that's what our client wants, let's do that. Let's get you some money back, and then you can kind of move forward with that. So we got some more decisions that we're expecting in the very near future. We'll be keeping everybody up to date on those outcomes and how this whole campaign is going forward, as some people have described it.
Yeah. Well, great job, Brian. This is many, many, many years and hours in the making. I just like the amount of mental space in my life I've given these issues. It's like, well, at least we got a victory before I'm dead. So that was good. I was not all for waste there, because this is how you and I first met, as me like being pounding on the table. Probably this doesn't make any sense, Brian. I need your help. I need your skills on my team to help me battle this. So cheers to you.
Yeah, well, thanks, Meg. Thanks. I mean, this is a team effort all along. We got a lot of folks on our team working on these very hard, making the arguments, and Meg, these arguments started with your brainstorming, and yeah, we're gratified to see some good results coming out of this. So thanks, Meg.
Well, that's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, may the wind be at your back.